Hey guys, it's Kathy. I hope you're doing well this late evening or early morning, whatever it is for you. I don't know. I'm East Coast, so it's probably still really early in other places. So we'll just say late night. I got some weird ones. I don't even know where I'm going today. There's just. I don't even know. Okay, let's start with the first one, and then you'll see where this whole thing is going. It never gets better after the first one. The first one is what you can expect from all of them. This poor boy, it just sound right. Something is fishy here. And I think I believe the boy more than anything else. But you make up your own mind. Here we go.
Next, we have position number 10, Mr. Little.
All right, Mr. Little, your case is 24 CR 0000354A. You're charged with 2 counts of battery family violence and 1 count of cruelty to children in the 3rd degree. Do you understand your rights?
Yes.
All right, Mr. Howard.
First arrest, he's 18 years old.
Okay. All right, Mr. Abdullah.
Yes, Shauna. At this time, the facts show that on January 14, 2024, officers responded to 3150 Middleton Road, apartment number 450 in Atlanta, Georgia, on a domestic dispute call. Upon arrival, they met with the victim, who is the defendant's mother, Jasmine Cullins. Ms. Cullins advised that a fight began between her and the defendant after she approached the defendant about cooking a meal without permission. The victim, Ms. Cullins, told officers that she was punched by the defendant and tackled. At one point, she had to grab a knife for her protection as she was afraid for her life. In the scuffle, Mrs. Cullins' fingers was cut. When the defendant's little brother tried to break the fight up, Marlon Little, the defendant turned around and punched him in the face, as well as choked him, causing visible injury. All of this was done in front of the minor child, who was the defendant's younger sister. He also attempted to hit the younger sister because she is the one who told the mother about him cooking the meal. At this time, the state is requesting a $3,000 surety bond. No further contact with any of the victims, that is Jasmine Cullins, Marlon Little, or his minor sister, Cassidy Little, and stay away from the incident location at 3150 Middleton Road, apartment number 450. This is based off the defendant's risk of reoffending, as well as his risk of intimidating the witnesses or the victims in this case, because he lives with them. Nothing further from the state, Your Honor.
All right. And the mother's last name is Little?
Cullins.
Cullins. Is Miss Cullins on the line? And I don't see anyone with that name. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 18 years old. He tells me that he's currently employed. He works for the school from which he just recently graduated. My client denies that he was the aggressor here. He tells me that his mother was the one who became aggressive with him, and he was just trying to defend himself from what she was doing. Just based on what the state is alleging, it sounds that my client may well be telling the truth, because I cannot imagine a mother accosting her child about cooking a meal. It just doesn't sound right. But my client denies that he assaulted his mom or battered his mom in any way. He tells me that she was the one who came and mushed him in the face and started to attack him, Your Honor. He does have another place that he can go. I would ask the signature bond through the jail. He's 18 years old and he's employed, so my understanding is that he can sign his own bond, Your Honor. He tells me that he is going to go to live with his grandmother, so he doesn't have to go there. But I certainly would ask to no further violent contact, Your Honor, especially with his siblings, which is what he would prefer.
Oh.
Nothing further, Your Honor.
All right. Defendant is going to receive a $3,000 signature bond through pretrial level 1. That'll be $1,000 on each count. He's to have no contact whatsoever with any of the victims at that time. At this time, of course, that can be revisited at a later date. He's going to take the 1-day anger awareness course. And additionally, he's to have no drugs, no alcohol, or weapons as a condition. Is there anything additional?
Nothing, Your Honor. So he will be able to sign his own bond since he's employed and he's 18.
Let me ask, Mr. Howard, I've heard conflicting things. I've heard so far people under 21 are being required to get co-signers. Can pretrial take someone 18?
Whatever you order.
All right. I won't require that he have a co-signer at this time. All right.
You will not require?
I will not require.
Okay. I didn't hear the not. All right.
Not required. All
Thank
right.
you.
Holly, put that on the bond order, please. Because otherwise they'll jam him up.
We don't want that. All right.
Will do.
All right, Mr. Little, that concludes your case. Best of luck to you.
Thank you, Your Honor. And that concludes my business before the court today. May I be?
Okay, can we just forget about everything we just heard for 1 second and just congratulate her on she's drinking her coffee and, you know, saying I'm not. And she cheers. She like puts her cup up in the air, cheers. You know, only good drinkers at a bar do that. So me and her could be besties. All right, now back to the case. I believe the son. All right, maybe I'm biased because I would die for my 20-year-old now to cook something, anything, a peanut butter and jelly. I don't care, but I would never. I don't know. He cooked a meal and then this chaos happened. I believe the son. I believe mom flipped out because he cooked a meal. That's what I believe, and I believe that the fight happened in front of the other kids because mom started it. And I'm a mom, so you know I'm on his side. He's an adult now, so this wasn't a minor. Don't worry. All right, nothing gets easier than that tonight. There was no answers. We didn't find out what happened, and that's the way it's going to go for the rest of the night. Let's go to Arizona. Let's go out to Arizona.
Form with initials on the left-hand column. Are those your initials?
Yes, Your Honor.
You read that and understood it, and had you any questions? Mr. Edgerton was available, am I correct?
Yes, Your Honor.
Okay, so on the first page of that document, the initials, left-hand column are your initials.
Yes, Your Honor.
Following page, initials, left-hand column, your initials.
Yes, Your Honor.
Following page, initials, left-hand column, your initials.
Yes, Your Honor.
Okay, and on that page also your signature, am I correct?
Yes, Your Honor.
Okay. This is okay. Do you, sir, are you a citizen of the United States?
Yes, Your Honor.
Okay. This is an enhanceable offense, which means that if you're charged in the future with another harassment charge, a second offense is a gross misdemeanor. Gross misdemeanors are punishable up to a year in jail and up to a $2,000 fine. If you're convicted of a third,
The only reason I'm pleading out is because my dad needs my help.
hold on a minute. Okay, that we also may, I take it, anything past the second, is that a felony? Irma, Mr. Edgerton?
Yes.
Okay. Third one, and there's no time limit. If you get another harassment charge, sir, without any particular time limit, like they have with the DUI, it's a felony and you can't go to prison. Do you understand that?
Yes, Your Honor.
Okay. Do you have any questions in regards to your plea?
No, Your Honor.
Okay, what is your plea to the harassment charge?
No contest.
Okay, I find that plea is not involuntarily made. Let me get back to the regular calendar. Okay. 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 Pursuant to that plea, charge in 23 CR 11673 is dismissed. You just pled to the 23 CR 15994, and the charge in 24 CR 00086, the possession charge is dismissed. Okay, are we ready to do sentencing today?
We are, Your Honor.
Okay, go ahead, Mr. Boytis Tanner.
Thank you. For the record, as I previously indicated, we have the victim present, and her name is Evangelina Selafu. And that's spelled, the first name is Emangelina. The last name is Cefelu. Also on Zoom, we have Evangelina's stepfather, Roy Gibson. And the victim would like to give a victim impact statement at the appropriate time. So this is what happened, Your Honor. There was a protection order in place protecting Ms. Cefelu. That protection order had been in place since November. Date of offense is December 19th. On that date of offense, the defendant was observed banging on the victim's door, trying to get in, trying to break locks on the doors, and locks on the windows, trying to get in. Mr. Gibson, victim's stepdad, reported that the night before, defendant came in looking for the victim with a gun. And on the date of offense, the stepdad armed himself with a metal pipe to protect himself and protect the victim in this case. The victim reported that she was very fearful of the defendant. Mr. Huertas is 38 years old. I'm showing on his criminal history that he's a veteran, possibly. I don't know if he was honorably discharged or not. But what I do have is a criminal history that is escalating. It started in 2010. He has some drug charges on his record, which appear to be from some sort of base, maybe while he was still active military. In 22 and 23, I have at least 4 arrests for failure to comply or failure to appear. Also in 2023, I have a carrying a concealed weapon or dagger arrest, multiple ONRs, and multiple drug-related arrests. With this, Your Honor, as well as these egregious facts, I think that this is a 6-month in jail case. The reason for that is because this type of behavior places the victim at great risk. This is how victims get hurt. And the court should send a strong message to Mr. Huertas that this behavior will not be tolerated, and to send a message to the victim that we will do what we can in the criminal justice system to protect her. Thank you.
Okay. All right, Mr. Edgerton.
And Your Honor, I agree with Mr. Boytis Tanner to the extent that this is a case that warrants a significant sentence. However, I would ask that the court suspend that sentence and order Mr. Huertas to get treatment. The indication is that, again, we have a history of service to the community and to the country. We have what appears to be some self-medication through drug use. And so I think a more appropriate resolution here, and Mr. Huertas has not been interested, to my knowledge, in participating in our specialty courts. A more appropriate resolution, in my mind, is a significant suspended sentence with an order that he obtain a mental health and/or substance abuse evaluation, comply with the recommendations thereof, and then obviously have no contact with Ms. Cefelu or her family or her apartment, in addition to obeying all laws.
Thank you. All right, is Evangelina available for a statement?
She sure is.
Okay. Let's have her sworn, please. And if you can say something, see you on the screen.
I couldn't hear that.
Oh, there you are. Okay. You. Okay. Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay, go ahead. Make a statement, please.
I didn't mean for it to go this far. Michael just repetitively kept breaking into my room.
I'm sorry. Slow down, talk up. I can't really understand you. Go ahead, please.
I didn't mean for it to go this far. He just kept repeatedly breaking into my room when I wasn't home. I come home and kind of the stuff that I've been through, I kind of get freaked out, when I, see they come into my room and there's a man standing in my room. At first glance, it freaks me out, you know what I mean? And just repetitively when I'm asleep, like I hear someone trying to break into my room. It's kind of intimidating. My stepdad, he lives 2 doors down from me, so he can hear it happening, and so he would come out and see if I was okay. I mean, like I said, I didn't mean for it to go this far. I just don't want to be freaked out anymore. You know what I mean? When I'm at home, and he's not allowed on the property, so I kept telling him he was going to get me kicked out if he continued to break in. You know what I mean? And I can't lose my place. Yeah.
How long were you dating him or with him?
6 months or so.
Excuse me?
About 6 months.
Okay. All right. Anything you want to add, Mr. Voitis Tanner?
No, Your Honor, thank you.
Okay, Mr. Edgerton, anything else?
Your Honor, just that the victim's comments seem consistent with a desire not to see Mr. Huertas punished, but rather to have this conduct stop and maybe to have him receive the help he needs. So I'd ask the court follow my recommendation.
All right, Mr. Huertas, anything you want to say?
Yes, Your Honor. Due to the fact of who's around her right now, he is manipulating her. That is not her stepfather. That is what he's telling her to say. And sorry, Angelina, but we've been together for 6 months. We were together up until the 28th. That's the day I got arrested. I'm not sure if we're still together or not. That's, probably not going to happen. I never was breaking into her room, but I was knocking on her door, and then somebody who calls himself his stepfather is 2 doors down from her and manipulates her, and then she was trying to find a way to tell him that we were together and that I wasn't doing that. But it's all, whatever anybody wants to say, but she won't say that because of who she's around right now. And that really bugs me that she's willing to say that about me but it's all right. I'll stay away, and I will never have contact with you or anybody around there ever again.
It wasn't like that. It wasn't supposed to be like that.
No, I don't even want to hear it. I don't want to talk anymore.
All right. Yeah, you won't see her for another 6 months. I'm going to send you to 180 days, Washington County Jail. No alternative sentencing, and
what, sir?
Credit time served towards that. Thank you. All right, let's go to the next case. Will be.
I am just as shocked as you all are. I can't believe he did that, and he did it. 6 months in jail. Did it. Just like that, without blinking. And then it was over. And I don't know who I believe. He said that they were dating up until the 27th when he got arrested. And she's saying, it doesn't matter. She's probably right. I probably don't believe him, but I don't 100% feel strongly about it. I just don't know who to believe in. He came from left field on that one. Like, he must be having a bad day. I don't know. He's so nice, and he gives people chances, and he's like laid back, and then he just sent this guy away for 6 months. All right. Okay. All right. Now this one gets really good at the very end. The prosecutor throws something at us at the very end that changes every single thing that we've just heard. Here we go.
All right, I've got Mr. Bauer. Zoom here. And this is People v. Kevin Bauer, file 23-6647FH. And Mr. Bauer, let us know if you need to talk to Mr. Clayton at any time. I can create a breakout room for you to talk to him privately. We are here for a docket call. I've been handed a plea agreement for a plea to an added count 4 of misdemeanor larceny. Is that how we're proceeding with a sentence agreement of no jail or probation? Is that how we're proceeding, Mr. Plain?
Yes, Your Honor.
All right. And I have an amended information adding that count. Do you consent to its filing?
I do, sir. I'm waiving the same.
Okay. All right, Mr. Bauer, a misdemeanor plea to larceny over 200 but less than 1,000. It's a misdemeanor punishable by up to a year in jail and or a $2,000 fine or 3 times the value, whichever is greater. Do you understand the maximum?
Yes, Your Honor.
Now, you would have the right to a trial by judge or jury, to be presumed innocent until the prosecutor proved your guilt beyond a reasonable doubt, to confront and cross-examine the witnesses against you, to present witnesses in your own defense, to be assisted by an attorney at that hearing, and to testify in your own defense or to remain silent and not have your silence used against you. Do you understand all those rights?
Yes, I do, Your Honor.
Do you wish to waive those rights and plead guilty to that misdemeanor charge?
Yes, Your Honor.
Okay, now there's a sentence agreement, or there's a plea agreement that in exchange for that and restitution being agreed upon at $523.33 joint and several with a co-defendant, that there be a sentence agreement of no jail, no probation, and the remaining charges and enhancements would be dismissed. Do you understand that plea agreement?
Yes, Your Honor. Just one clarification. So it's $500 combined restitution, is that correct?
Yes, it's $523.33. That's joint and several with Ms. Kruger.
Okay. I just wanted to confirm. Thank you.
That's not, each of you don't own it. Oh, that is a total of the 2.
Yeah, just a total. Okay. Very good. Thank you.
Okay. Mr. Bauer, other than that plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Mr. Cleone, are you aware of any other promises, threats, or inducements?
I'm not, sir.
Mr. Juliet?
I'm not.
All right, Mr. Bauer, then how do you wish to plead to the charge of larceny over 200 but less than 1,000?
Guilty, Your Honor.
Mr. Cleone, would you assist with a factual basis?
Yes, Mr. Bauer, on or about, so this is around this time, back April of 2019, were you in Mentor Township, Sheboygan County, Michigan?
Yes, on Berry Creek Road. Yeah, I guess. Yeah. What year again? I'm sorry.
Around 2019 or sometime thereafter?
Yeah, right when Dave died. Yes, I was.
Okay. And you said Dave being a person that you resided with?
Dave Hodges. Yes, he was. Well, I know you don't have. He was with Linda, which is my girlfriend's mother. They'd been together for 30 years, and I was renting. Angel and I were renting a place from him there at his house.
Okay. And when you moved out, sometime after that date, did you take with you a firearm?
No, sir.
Did you later find that there was a firearm that was in your possession?
When we were moving, it was found in our storage.
Okay. Did you have authority from anybody to take that firearm?
I don't understand the question. Like,
did somebody give you permission to take the firearm out of the house?
I never took a firearm out of the house. It ended up in our stuff because it was just, insanity trying to get out of there. Dave died suddenly, and we had all our stuff in storage, and then we moved it all to another place. So there was a firearm that ended up with us in storage. So I guess to answer your question, no, I guess there was no authority, I guess. Okay.
And at some point later, you found the firearm and ultimately had the firearm when you were arrested in Emmett County on an unrelated charge, correct?
Yeah, it wasn't actually on me. No, it wasn't.
It was just in your possessions.
It was in the hotel room. Yeah, it was not with me.
All right. And did the firearm have a value of more than $200 but less than $1,000?
I roughly, yeah.
Okay.
I would imagine.
Okay. I'm satisfied as a factual basis. I'd ask Mr. Juliet to confirm if he is or not.
Well, Mr. Bauer, you said this was as you were leaving a residence. Who packed up all the stuff to leave the residence?
It was in the basement. Our stuff was in the basement. It was
I didn't
me and
ask you where it
Angel.
was. Hold on. Listen to my question.
Yes, sir.
Because you're telling me you didn't take this gun. You're pleading guilty to taking the gun. So I got to find out. You said it was in your stuff. Who packed your stuff? Did somebody else pack your stuff?
Get him,
It was a total
Judge.
mistake?
Get him.
No, it was unintentional. I'm sorry. It was unintentional. It was unintentional.
Well,
it ended up with us.
Who packed it up?
When we packed all of our stuff, it ended up with our stuff. And it was not intentional to take the firearm.
Okay, but you and Ms. Kruger packed it up together. Is that right?
That's correct. Yes.
All right. That's what I wanted to establish. So it ended up in the stuff that got packed, and you're the one that did the packing. All right. I'm satisfied with that factual basis. For you, Mr. Juliet?
Yes.
All right. Well, Mr. Bauer, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I'll accept your plea. Is this something where we could proceed with immediate sentencing?
I would ask that we proceed today.
Okay. Any objection, Mr. Clean?
No, Your Honor.
Okay. Go ahead with any allocution.
Thank you, Your Honor. This obviously is a time that's somewhat removed from today's date. I think it benefits the court to know that, as I referenced, there is an interplay between this and a case that occurred in Emmett County. I was not the attorney of record in the Emmett County case, but I will indicate that I confirmed with probation, parole, and with Mr. Bauer that the discussion of the firearm, Mr. Bauer was charged with a firearm offense in Emmett County that was ultimately dismissed when he pled guilty to some other charges. But the issue of the firearm was taken into account when Judge Deegan assigned the sentence in Emmett County. So he has already received punishment for this. He's remains on probation for the offense in Emmett County, so he still has some probation to figure out and finish up. Mr. Bauer just wants to put this behind him. And I don't know, I can't speak for Ms. Kruger as to what she's going to do, but Mr. Bauer wants to put this behind him and move on with his life. So I'd ask the court to sentence as recommended to no probation, no jail, and let Mr. Bauer put this chapter of his life behind him. And thank you, sir.
All right, thank you. Mr. Bauer, it's not required that you make a statement. It is allowed. Is there anything you want to say or no?
I have a statement, if that's okay to put on record.
Please don't.
Okay.
Please don't.
Angel and I didn't intentionally take anything from Dave Hodges. I knew Dave because he was, for all intents and purposes, my girlfriend's stepfather. I was always welcome in his house. I paid rent when I stayed there. I helped him fill his heating fuel in the winter and carried his propane tanks for his camper. Dave was a retired surveyor and master welder and a friend. I truly valued his wisdom, and it broke us when he died so suddenly of a stroke. In the aftermath, his relatives tried to paint us as vagabonds and grifters when nothing could be further from the truth. I work hard, but I've made mistakes, and I've paid for those mistakes and the bad choices that I've made, and atone for my sins. Angel and I valued the love that Dave offered the world, not his stuff. And that's all.
All right, thank you. Mr. Juliet, any recommendations from the people?
I would just ask that the court follow the agreement between the parties, as well as $523.33 in restitution that's joint and several with the co-defendant. As Mr. Clayton said, this sort of, the facts giving rise to this are sort of mirroring what happened in Emmett County. It was maintaining a meth lab, and they did get some pretty harsh punishment over there. So I would just ask the court to follow the agreement.
All right, well, clearly there's more factual context toward this case and the Emmett County case than I really have possession of knowledge of. But the defense counsel and the prosecutor, they know all those facts and believe that this is a reasonable outcome, and I've got no information that would cause me to doubt that. So I'll sentence as recommended here. There's restitution ordered of $523.33. That's joint and several with co-defendant Ms. Kruger. There's $50 in state costs, $75 in the crime victims assessment, and $350 in court costs. And I'm not going to place you on probation or impose any incarceration, Mr. Bauer. So that'll be the sentence of the court. You can make your payment arrangements with the clerk's office. If you need to set up a payment plan, contact the Sheboygan Circuit Court office and we can assist you with that. We are entering a judgment. So if you want, you can appeal to the Court of Appeals, but you have to do that within a certain period of time. So we're going to get you a copy of that appeal paperwork for you to fill out. We're going to ask you to send one back into us that you initial, that you have the copy of it. The other one's for you to fill out if you want to take an appeal. Okay? Any questions?
Very good. Thank you, Your Honor.
Okay. Good luck to you, sir.
All right. Thank you.
What in the world did I just watch and hear? Wait, what? Huh? Okay. First off, Aaron, you really disappoint me. This judge is hard on people. They don't get away with half pleas. They don't get away with not pleading guilty when they're guilty. And this guy just skated through that plea like he was Mother Teresa and did nothing wrong. And the judge just like, okay, I'm satisfied. But what do you mean you're satisfied? No, you're not. Get him. And then the prosecutor at the end is like, yeah, I think you did it on purpose. Like operating a drug house. Who's operating a drug house? That old man is operating a drug house? Get out of here. What did I just watch? I do not know. Let's just walk away from that one and go to a different one.
All right, how about Eric Kahn, 24 CR 00056. Hi, Mr. Kahn.
Hi.
All right, looks like we're here on a sentencing for a simple battery. I didn't pull him up earlier because I didn't see anybody else on our Zoom call. So, Ms. Gianoli, are we ready to move forward on him today?
We are prepared to proceed, Judge. Ms. Ramos in our office did speak with the victim in this case. He's a security officer. He indicates that he works graves and would be unable to attend sentencing.
All right. So please give me your recommendation.
Thank you. Judge, did you also indicate in the case sending in 1133 that we're before you for a revocation on an O&R?
I don't have that. Hold on just one sec.
And we also had that question at an appropriate time. I wanted to ask a clarifying question on that.
Okay, so hold on just one moment here. Ms. Gianoli, what's that case number?
It's 23 CR 11333. It's a 30-day suspended sentence for an obstructing and resisting conviction.
All right, hold on just one second. I apologize. I may have overlooked that here. And that's a 30-day. Okay, hold on. So, Mr. Kahn, you got to give me just 1 minute here. I just want to pull that up because I overlooked my notes here.
I didn't see that either. What was the case number, Angie?
It's 23 CR 11333. 30-day suspended sentence.
I wonder if they have him in on a different name. Let me see.
No, I don't think, and I think Tom was the one that pulled it up and added it to our list.
11333.
Can I tell you why, Your Honor?
Wait, just 1 minute here. I just want to make sure I've got all my paperwork here. I want to make sure I understand everything everybody's saying.
Oh, I'm sorry, Judge. So his name is spelled different. His name is spelled with a C, Eric C, in the 23 case, the one that Angie's talking about, and we have him as a K. So that's why I didn't see him in there.
Okay. So, Mr. Kahn, how do you spell your first name? With a E-R-I-C or E-R-I-K?
E-R-I-C.
Okay. So in case number 24 CR 00056, I'm going to amend your first name to Eric, E-R-I-C. You will do all further proceedings under that name. So give me just 1 sec here, Mr. Kahn.
Judge Champagne is laid back
like
too.
That was an old obstructing and resisting matter. Okay. So, Mr. Kahn, do you understand that, well, I guess this question was asked previously, that you understand I do have the ability to revoke that old suspended sentence on top of whatever I do on this case here today, right?
Yes, I kind of wanted to clarify. I was...
no, stop.
Yes, sir.
You'll get your chance. Let me hear from the lawyers, then I'll hear from you, okay?
Yes, sir.
Okay, if there's anything left to clarify, that's your job at the end.
Yes, sir.
Okay.
It sounds like Mr. Edgerton may have a clarifying question. Could we ask that first? That might guide me too.
Yeah, I appreciate that. And I think what Mr. Khan was trying to get at. So on the 18th of September, this court imposed that suspended sentence that was for 1 year. Mr. Khan reports that he remained in custody through December. I'm not able to tell at this point, and perhaps our courtroom deputy can help us, but Mr. Khan was a little bit unclear as to whether he essentially timed out that time or whether he was doing that roughly 30 days or 90 days on some other matter and then would still have this 30 days over his head. Based on the paperwork that I'm seeing, I'm guessing that suspended sentence is still in effect and that he probably did about 3 months in custody on some other matter, but I don't know that for sure.
I was arrested on the same case. It was the same charge.
Let me hear from the deputy. Is that Deputy O'Connell? I haven't seen anybody there.
Hold on, I'm looking it up, Your Honor.
Thank you. And Mr. Khan, I'm not trying to discount what you have to say. I just want to see what the official record has to say, and then you can maybe clarify everything, okay?
Yes, sir.
All right.
September 13th.
So, Mr. Khan, you've been in jail and then out of jail and then back in jail on this new matter?
Yeah, I was I was given the I believe the 30-day suspended on the 18th. I remained in custody till December 1st, which is a few months later.
Yeah.
And I thought it would shouldn't that time out? Shouldn't that expire?
Well, and it would if you didn't have another case that was keeping you in jail.
It was the same situation. It was the same case, different charges on the same case. So that it was the same case essentially.
All right. Well, we'll take a look at that and see, because you wouldn't be held in jail for 90 days on a 30-day suspended sentence, right?
I understand. It was like I was saying, it was the same case, different charges. I'm just trying to keep my job.
I got you.
Yeah. I've been here since New Year's. I don't normally fight, and I'm just trying to keep my job.
All right. Well, let me just hear about your ins and outs. I want to make sure you get the credit that you are entitled to. All right.
Yes, sir.
Okay. So
I have to tell you, he's about to get exactly what he's entitled to.
So hang tight. Let's hear from the deputy, just to make sure that you're not getting credit for something. I don't want you to get double credit unless that's what I intend. So hold on just a sec.
So you did it 80 days in jail, that last sentence?
Yeah, it was basically the same situation, separate charges, the same case though, and it was for.
So what I'm looking at is we're doing time for the drug paraphernalia, correct?
Yes.
And then they released you for the resisting public official, the suspended sentence, correct?
Yes, but I wasn't released until the first.
Right.
Yeah. So it totaled over 90 days in custody.
I don't know if it was 90 days. I've got 80 days.
Or 80, somewhere around there.
So, Your Honor, from what I'm looking at right now, his last day, he was in custody for 80 days. It looks like he was doing time for drug paraphernalia and was released with the resisting public official with the suspended sentence.
Okay. All right.
And I was 80.
So, Mr. Khan, the way I look at it is I have the full power of the simple battery charge today, plus the 30 days on the old resisting charge. You understand that's what you're facing here today?
Yes, sir.
Okay. All right. So, Ms. Giannoli.
Your Honor, here, as we've discussed, there was a suspended sentence imposed on him for an obstructing resisting back on September 23rd. One of the conditions of that case is that he stay away from the Calneva. The case in which we're before you for the simple battery in position, he again entered the Calneva on January 1st, where security was advised that he was uncooperative and aggressive. He was told to leave and he turned around and punched the victim in the face. I think I indicated the victim, although he was unable to make it to the hearing today, was desirous of a stay away order, which has already been put in place and unfortunately violated by the defendant's subsequent actions. That said, Your Honor, his criminal history is of concern to the city. He has 30 pages of criminal history. This appears to be his 5th crime of violence. 2019, he was convicted of a domestic battery second offense. 2018, convicted of a battery. 2015, convicted of a domestic battery first offense. And although later in time, he has a 2012 robbery case, there is no disposition on that one, candidly, Judge. He also has a variety of failures to comply and failures to appear. I've only been able to look up to 2018 in that matter, but he had 1 in 2022, 1 in 2021, 3 in 2019, and 1 in 2018. As indicated, the subsequent offense was also done in violation of both a suspended sentence as well as a stay away order. Judge, I believe the continued imposition of a suspended sentence here would be an exercise in futility, given that it is his 5th crime of violence, and given his history, he's not likely to comport with any court orders. I'm asking that you revoke the 30-day suspended sentence, impose that. Consecutive to that, Judge, I'm asking that you impose a 60-day jail stint. Once he's done, I'm asking for you just to have a stay away order and exercise your contempt power should he violate that, Judge.
And Ms. Giannoli, I apologize. Somebody coughed here. I didn't hear the recommendation for the actual days.
I'm asking for 60 days jail, Judge, on that.
Okay.
Battery.
All right. Thank you. All right, Mr. Edgerton.
Your Honor, I'm trying to think through some of the same facts that Ms. Giannoli just put before us, which is we have an individual who has a history of criminality in addition to some violent offenses. And again, someone who within a month of this court's of release under a suspended sentence found himself again at the Calneva. On the other hand, Mr. Khan has expressed repeatedly his urgency to get back to work. And I think we know that, we can at least surmise that some of what he's going through is the difficulties of being between jobs, just needing to kind of get on a better path. I would ask the court to take a different approach to a similar set of challenges, which is to reinstate Mr. Khan to the 30 days, impose 90 plus days as a suspended sentence, a much more severe penalty than the city's asking for, and to release him, but with a testing tail. So maybe 60, 90, 120 days of ongoing testing to make sure he gets out, remains clean, is going to work and is able to get his life back on track. I think that we can also understand this was early morning hours of January 1st. He allegedly returned to Calneva. We can probably guess what happened there, it being New Year's Eve. And so I think Mr. Khan is clear in his desire to get away from this. He made a comment to the effect of, I don't usually drink. When I do, things change. And so we need to support him in not drinking. We need to get him back to work, keep him sober, and ensure that there is accountability over his head to make this doesn't happen again. So our request is to be reinstated on the suspended sentence and given a suspended sentence. In this case, we would advise something in excess of what the city asked for, but suspend for a period of time to include a testing tail following his release.
All right, Mr. Khan, what would you like to say?
I think that I could agree with that.
Okay.
Yeah, because I need to get back. I don't want to lose my job, so, and I'm already working. So,
what are you doing?
I work at Jackson's, the one on 4th and McCarran, at the gas station, the extra mile.
Yeah. What do you do there?
Cashier.
Okay. So, Mr. Khan, here's my concern, right? I think that your lawyer makes some very valid points. I think there's probably a substance use disorder problem that we're dealing with. I don't know if there's a mental health problem, but we've got 30 pages of criminal history. We've got violence. We've got nuisance. We've got multiple opportunities for you to try and do something to try and fix this. And from everything I'm seeing, you're not doing that. What concerns me is the violence. I can't have people getting punched in the face. That is not the way that our society works, and that makes me very, very concerned. So here's what I'm going to do. In case number 23 CR 11333, I am going to revoke your suspended sentence. You will do the 30 days that was previously suspended over your head. In case number 24 CR 00056, what I'm going to do is I'm going to give you 120 days suspended under the following conditions. Number one is that you do 30 days up front on that, consecutive to 23 CR 11333. So you're going to do 30 plus 30 as far as I'm concerned.
Do I get credit?
Yes, you'll get credit for whatever you've been in as long as some other case is not taking it. I'm putting this case consecutive to anything else that's keeping you in jail.
So what about from the origination of the suspended? Do I get the 8 days on that credit too?
No.
That I was in custody before I got sentenced to 30 days suspended?
Well, I'm going to leave that. I'm going to ask the jail and my court to take a look at that. If you were held in jail prior to sentencing and you were not getting that credit taken up on another case, I will give you that 8 days. I'm giving you nothing from the time of your sentencing until you got out of jail. That's my intent. Do you understand that? Yeah, okay. That case, whatever the other case is, that took up all of that credit. Okay?
Okay.
All right. So for the suspended sentence, you will obey all laws. You will stay away from the Atlantis, no matter what. There will be no...
Calneva, Your Honor. I apologize.
Calneva, excuse me. I just saw the Atlantis on the case above me. On the you will stay away from the Calneva. And you will do 30 days upon your release of medium supervision. They will test you for drugs and alcohol. They will see whether you are complying with that. All right.
She only wanted 60 days. I would only do 30 days in custody on 60.
Well, guess what? She's the prosecutor and I'm the judge. So I get to.
How much time do I got to do? How much time am I doing then?
Well, why don't you guess? Would you rather just do time?
Can I do 45 days, 30 and then 15?
All right, Mr. Khan, you're convincing me that there's no chance that you're going to comply with anything I have to say. You're revoked on 23 CR 11333 for 30 days. On case number 24 CR 00056, you're given 120 days consecutive. That's it. We're done.
What? What just happened? What is going on today? Did you see that? He was about to give him 30 days. He gave him 120 days plus 30 days. He wasn't even that bad as a defendant, as an inmate. I mean, we've seen much, much, much worse, and they don't get nothing. This guy just got 120 days. Oh my gosh. Yeah. I'm going to the next one. This one's funny because this next one, if you listen to his first charge, it's pretty bad. But then the magistrate throws a much smaller charge from years ago at him, and he's like, never, I would never do that. And I think, okay, I just have to tell you, this jail, it's that jail that I get some people and they look like mentally incapacitated. No, it's freezing in this jail. This jail is freezing. Everybody who comes in front of the judge is just huddling themselves. Big guys too are just huddling themselves. Not only that, this guy is detoxing hard right now. So he looks bad. He just looks real bad. He's okay though.
Again, jail, do we have multiple defendants in the courtroom, or are we bringing them in one at a time today?
After him, the last four will come in.
This was earlier tonight.
Evening, I'm Judge Shade, and you, sir, are? Mr. Bermudez.
Yes.
I have a number of things here for you. First, we're going to talk about is an interim complaint charging with possession of paraphernalia and possession of dangerous drugs, alleged to have occurred earlier today. We'll appoint legal defender's office to represent you on these charges, and did either counsel wish to be heard on conditions?
Yes, Your Honor. This is a personal use case. He does have the probation violation hold, it appears. I'd ask that you set the bond at $500 and a smart court hearing.
Preliminary hearing is going to be January 26th at 1:30. Smart court hearing will be January 23rd at 9. The Superior Court, bond is $1,000. If you post the bond, it will be included in pretrial services. Then I have a whole stack of misdemeanor files for you.
Sure.
You took what?
Hold it in for a second.
Charges from October 30th of 2020 for criminal damage, along with multiple failures to appear, most recently 4 days ago. Last year on the 12th. Possession of marijuana, October 16th of 2020. Failures to appear.
You got the wrong person. I don't do that.
Well, that was back.
He doesn't do that.
No.
Better than 3 years ago.
No, never carried marijuana in my life. Never.
Well, possession of paraphernalia on June the 12th of 2023.
That's not me.
Along with failures to appear.
That's not me.
We'll appoint City Public Defender's Office to represent you on these charges.
Well, you guys better make sure who you guys charging at, because I don't.
Your next court date on these is going to be February the 14th at 9 o'clock in the morning in the Tucson City Court. No alcohol or illegal drugs. If you're still in custody, they'll just review the matter. If you're out of custody, you need to appear. Do you understand that?
It's for 2 o'clock.
Right? Thank you, Mr. Bermudez.
You're welcome.
So he gets charged with, I don't know which controlled substance, fentanyl or heroin or cocaine, and he's fine. He blows that off. But charge him with marijuana, no way, that is too far. He would never do that, guys. Never. All right. This next case, I didn't get the whole thing. The whole thing wasn't good. Just this one part was good. The rest was boring. And so here we go.
Okay. So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights. Yes. And you understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial. Yes. Also, you don't have an automatic right to appeal the plea that you're making here today or to try to get it reversed. If you wanted to try to do that, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that? Yes. Has anyone threatened you with anything to get you to plead guilty? No. Has anyone promised you anything other than what we've said here in court today? No. a free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty? Mr. Trush, if you could establish a factual basis, please.
Thank you. Mr. Gentz, were you here in Otsego County on or about February 14th of last year, 2023? Yes. And was that at 825 Center Avenue? Is that where you were living? I'm sorry, Village Parkway at the time? Yes. And on or about that date, was Anna Romero at your home? Yes. And Anna Romero is at your fiance's mother? Yes. And on that date, was she sleeping on your couch? Yes. And did you touch her buttocks? Yes. I don't think there's any additional questions needed.
Judge, I think we need to establish it was done for a sexual purpose and not by accident or some other way.
And that was her bare buttocks? Yes. And that was for a sexual purpose? Yes.
Thank you with that, Mr. Rolla.
With that addition, the people are satisfied that there is sufficient factual basis to accept the defendant's guilty plea to add count 2. Courts comply with court rule statute as to acceptance.
I'm telling you, I don't know what's going on today. I don't know what people are thinking. I just know that he's in a lot more trouble. Like he says his fiance's mom, not his ex-fiance's mom. So I don't know what's going to happen when he finally gets home. But, you know, he was sentenced, not anything harsh, not like the other guy. and that was it. But what is going on today? All right, we got one more quick one. One more quick one that summarizes this day.
Hi. How you doing, Your Honor? Robert Rudy. Can I go home, ma'am?
Mr. Rudy.
Yes, Your Honor.
Charging you with shoplifting, alleged to have occurred earlier this afternoon.
Yeah, I'm sorry, ma'am. I went to go to the hospital. I'll go back to Keno, take my medication. I got off a chair appointment for Section 8 housing available for me this month. And I got my medication ready to go. I got glasses ready for off a chair to comply with my anger, you mean? So it can be better, I can let it go. I'm not trying to do time, Your Honor, because I get mistreated pretty bad here in jail at convenience time. I mean, I don't know who does what, but I just want to go home and see my mom. I haven't seen her in years because she had a heart problem. You know what I mean? I'm a pretty good kid still in heart.
Where does your mom live?
967 West Antonio, West Side, Tucson. 12 Valencia.
The problem is, you were just arrested for shoplifting.
I know, I can make it, Your Honor, I promise you. I'm sorry, please, Your Honor, please, trust me. Please, Mom, please. I'm sorry, Mom, I'm not there. I got raped. Pretty by this guy that she slept with. He mistreated me sexually with homosexuality. He touched my body. His name is Tim. You know what I mean? I'm sorry, Your Honor.
Okay, question for you.
Yeah.
What kind of medications are you on?
I have it's called Ritalin.
All of them.
Wellbutrin.
Okay. You currently under any sort of treatment?
Yeah, I'm according to order treatment. It's called anger for anger, and take my medication. Make sure that I go to anger classes with La Frontera on Princeton Mountain. Make sure that I don't go back to any store that I stole.
Blue outfit.
So February 1st.
What's your treatment agency?
La Frontera.
Is that a La Frontera date?
Princeton Mountain.
That's Wednesday, so January 31st.
All right, your next court date is going to be January 31st at 9:30 in the morning
Okay,
in the Tucson City Court.
What's happening?
That's a pretrial. You need to come to court. Okay?
So if I be released?
You will be released, but you need to comply with your treatment.
What does that mean, officer?
You need to comply with your court-ordered treatment. And you don't go back to TJ Maxx or that whole shopping center. Do you understand that?
Yes, Your Honor. I promise.
Thank you.
Well, Lizette summed it up best. What? What? What in the world is going on today? I don't even know. I don't even know what to say. I don't know what we just watched. Thank you so much, Jesco. I appreciate it. But I'm tapping out. I've had enough because this was just too crazy today. Out of left field all day long. I hope you guys had a good night. I think it's time to go to bed now, though, okay? Go to bed, guys. It's late. I will talk to you again soon.